Report of the Central State Relations Inquiry Committee, 1971, Government of Tamil Nadu, read by Ramani, Chapter 7, The Judiciary, the Supreme Court. According to the terms of reference to the committee has to suggest the measures necessary for securing, among other things, the utmost autonomy of the state in the judicial branch also, including the High Court. The judicial branch has the Supreme Court at the apex. Until April 1937, the Government of India was essentially unitary in character, and the question of a Supreme Court for India was not mooted. The High Courts in the three Presidency towns, namely Bombay, Calcutta, and Madras, were the most important, and appeals lay from them to the Judicial Committee of the Privy Council in England. The proposals of the British government for Indian constitutional reform, set out in the White Paper of December 1931, proposed the setting up of a federal court. The White Paper said, quote, in a constitution created by the federation of a number of separate political units and providing for the distribution of powers between a central legislature and executive on the one hand, the legislatures and executives of the federal units on the other, a federal court has always been recognized as an essential element. Such a court is, in particular, needed to interpret authoritatively the federal constitution itself. Unquote. The White Paper suggested the conferment of both original and appellate jurisdiction on the federal court. The original jurisdiction was to determine justiciable disputes between the Federation and any federal unit or between any two units involving a constitutional question. The appellate jurisdiction was to extend to the determination of appeals from any high court or state government involving constitutional questions. The Joint Parliamentary Committee, which considered these proposals, agreed with the principle that there should be a federal court to act as court, the interpreter and guardian of the Constitution, and a tribunal for the determination of disputes between the constituent units of the Federation. Unquote. The Joint Parliamentary Committee endorsed the proposal that the federal court should have exclusive original jurisdiction in relation to disputes between the federation and a unit or as between the units themselves. As regards the appellate jurisdiction of the federal court, the committee recommended that it should extend to the determination of constitutional issues. It also recommended that appellate jurisdiction should take within its ambit interpretation of federal laws throughout the whole of the federation. The committee specifically considered the point whether there should be a separate court of criminal appeal for the country. It came to the conclusion that a court of criminal appeal was not required in this country in view of the various safeguards provided for in the Code of Criminal Procedure and the right of petitioning the Governor and the Governor General. Under the Constitution, the Supreme Court is vested with jurisdiction in several cases. The Supreme Court exercises original and exclusive jurisdiction to determine justiciable disputes between the Union and the states or between the states inter se, Article 131. It is the final appellate tribunal of the country in all cases involving constitutional issues, irrespective of the pecuniary interest involved, and this jurisdiction extends to civil, criminal, and all other cases. Article 132. In civil matters, appeals lie to the Supreme Court, subject to the conditions specified in Article 133. Its appellate jurisdiction in criminal matters is regulated by Article 134. The appellate jurisdiction and the Supreme Court in regard to criminal matters has been amplified by the Supreme Court Enlargement of Criminal Appellate Jurisdiction Act 1970, Central Act 28 of 1970. Briefly stated, an appeal lies to the Supreme Court in all criminal cases where the High Court has, on appeal, reversed an order of acquittal of an accused person and sentenced him to death or to imprisonment for life or to imprisonment for not less than 10 years, and where the High Court has withdrawn for trial before itself any case from any subordinate court and has, in such trial, convicted the accused person and sentenced him as aforesaid. Apart from Articles 131 to 134, the Supreme Court has discretion to admit appeals by grant of special leave. Article 139 enables Parliament by law to confer on the Supreme Court the power to issue prerogative writs for any purpose other than that of enforcing fundamental rights. Article 32 confers power on the Supreme Court to issue prerogative writs for the enforcement of fundamental rights. The question is whether in a federal setup a Supreme Court should have the powers which it now possesses. As pointed out in the White Paper of 1931 and by the Joint Parliamentary Committee, a tribunal independent of both the federal government and the units is a necessity in any federal setup. This is the position in the United States of America, Switzerland, and Australia. In America, Article 3, Section 2, Clause 2 confers original jurisdiction on the Supreme Court in all cases affecting ambassadors and other public ministers and consuls and those in which a state shall be a party. In Switzerland, under Article 110, the Federal Tribunal has to decide civil law disputes between the Confederation and the cantons or as between any two cantons. Section 75 of the Australian Constitution Act confers original jurisdiction on the High Court of Australia, inter alia, in matters between the states or between residents of different states or between a state and a resident of another state or in which the Commonwealth or a person suing or being sued on behalf of the Commonwealth is a party or in which a writ of mandamus or prohibition or an injunction has been sought against an officer of the Commonwealth. The original jurisdiction of the Supreme Court conferred by Article 131 has to continue. It's also necessary that the Supreme Court should continue to have the power to interpret the provisions of the Constitution. The question to be considered is whether it should have the power to interpret acts passed by the various state legislatures, unless it be that the case involves the interpretation of the Constitution in relation to the state act. Again, should there be an omnibus provision conferring civil appellate jurisdiction on the Supreme Court, even in cases where the value of the subject matter is 20,000 rupees or more? Further, the exercise of criminal appellate jurisdiction of the Supreme Court is also a point to be considered. In the United States of America, the Supreme Court does not possess appellate jurisdiction in civil or criminal cases, that is, cases which do not involve constitutional issues. Neither the White Paper nor the Joint Parliamentary Committee, it will be seen, favored the inclusion of an omnibus provision in the Constitution Act conferring appellate jurisdiction on the federal court in ordinary civil cases. In our view, the Constitution should not provide for conferment of appellate jurisdiction in civil cases where it does not involve any constitutional issue. What applies to civil cases applies with greater force to criminal cases. In the United States of America, the Supreme Court does not entertain ordinary criminal appeals. We are of the opinion that it is neither desirable nor expedient to increase the workload of the Supreme Court in relation to ordinary criminal appeals. In view of the safeguards provided by the Criminal Procedure Code, it seems superfluous to provide in the Constitution for criminal appeals to the Supreme Court, except in a case where it involves a constitutional issue. We have, while dealing with Article 262, stated that in relation to interstate water disputes, the ultimate authority to enforce the awards of the tribunal constituted under the Interstate Water Disputes Act 1956, Central Act 33 of 1956, has necessarily to be the Supreme Court. We have suggested that the necessary provisions should be incorporated in the Central Act of 1956 for this purpose. Thus, it will be seen that the Supreme Court should continue to have the original jurisdiction conferred on it by Article 131. Coming to the appellate jurisdiction, it seems that it will be more in consonance with the federal concept underlying our Constitution and in keeping with the autonomy of the states if the appellate jurisdiction is confined to cases involving interpretation of the Constitution. The enactments of the states are operative within the respective states. There is no question of a state act having any extraterritorial application. It seems hardly necessary to burden the Supreme Court with the task of interpreting state enactments. The ruling of the High Court should be final unless it be that the interpretation of the Constitution is involved or it is contended that the state act conflicts with some provision of the Constitution, in which case a right of appeal may be provided for to the Supreme Court. Central acts, however, are enforceable throughout the country. There are instances where different high courts have given different rulings and the Supreme Court has to reconcile the conflict. The Income Tax Act is an example in point where the interpretation of a central act is involved. There should be a right of appeal to the Supreme Court from the decision of the High Court, whether or not the case involves a constitutional issue. We recommend that the Supreme Court should continue to have original jurisdiction under Article 131 and the jurisdiction conferred by Article 32 and the power to hear appeals from the High Courts involving constitutional issues and the interpretation of central acts, but no appeal should lie to the Supreme Court in other civil or criminal matters. Judges of the Supreme Court are now appointed in consultation with such judges of the Supreme Court and of the High Court as the President deems necessary. In ordinary judicial theory, the Supreme Court, like the High Courts, merely interprets a law. It says what the law means, but there is no denying the fact that the Supreme Court in another sense makes law. The controversy regarding the power of Parliament to amend the provisions of the Constitution relating to fundamental rights is an example. The law declared by the Supreme Court is valid throughout the country and all authorities are subject to its command. It's an all-India institution of the highest importance and may be said to occupy a position in the judicial branch of the administration, similar to that assigned to Parliament in the legislative branch. In conformity with this, it is desirable that the judges of the Supreme Court should be drawn, as far as possible, from the different parts of the country. In the United States of America, the policy of giving broad representation to the nation's religious denominations has been an important factor in some cases. It is attributed in some measure to pressures from the minority denominations for representation. Again, in the United States of America, presidents generally try to maintain a geographical balance on the court. In recent years, there has usually been one Catholic and one Jewish member in the court. Of late, there has been considerable talk of appointing a Negro to the court. In Switzerland, it must be ensured that the three official languages of the Confederation, German, French, and Italian, are represented upon the federal tribunal. Article 107. Regional considerations also influence the choice of the members of the tribunal. This committee recommends that in appointing judges of the Supreme Court, it is desirable to secure, as far as possible and without detriment to efficiency, representation for the high courts and the bar of the different parts of the country. High courts. In other federations, the highest court of the unit is under the control of the regional authority only. In the United States of America, in a majority of states, the judges are elected. In Australia, judges in the states are appointed by the state authorities. Granville Austin, in his book The Indian Constitution, Cornerstone of a Nation, has stated that in the draft constitution, the provincial legislatures had much wider authority to legislate on high courts than in the constitution. The salaries and allowances of the judges of the high court are charged on the consolidated fund of the state. It is therefore but proper and expedient that the state government should have an effective voice regarding the appointment, tenure of office, and conditions of service of the High Court judges. The High Court judges hold office during good behavior, and no change is called for in this regard. Article 217, it will be noticed, refers to consultation with the governor. The governor, when consulted by the president under Article 217(1), has to act only with the aid and advice of his council of ministers. It follows that the present practice should continue and no further provision is necessary on this point. Arising out of the suggestion relating to the appointment of High Court judges is the point relating to their removal from office. According to Article 218, read with Articles 124, 4, and 5, it is the President who has got the power of removal after an address by each House of Parliament is presented to him, subject to the requisite majority. Parliament has prescribed the procedure for the investigation and proof of misbehavior or incapacity of a judge of a high court and for the presentation of addresses by Parliament. See the Judges Inquiry Act 1968, Act 51 of 1968. A perusal of the provisions of the Articles and the Central Act would indicate that the state is completely shut out in the matter of removal. Even consultation with the state is not mentioned anywhere. The state is as much interested in the independence, integrity, and impartiality of the High Court as the center. It will be more consistent with the federal principle and in consonance with the autonomy of the state if it is provided that the power of removal should be exercised on an address being presented by each house of state legislature supported by the requisite majority. It goes without saying that the procedure outlined by the Central Act should be followed, with the modification that the powers and functions conferred on Parliament by the Central Act should be transferred to the state legislature. Considering the fact that the salaries and allowances of the High Court judges are charged on the consolidated fund of the state, the power to regulate the salaries and conditions of service of judges of high courts may be vested in the state legislature. In the first draft of the Constitution, the entire power regarding the salaries and allowances, leave, and pensions of High Court judges was in fact vested in the state legislature, subject to the proviso that the monthly salary of the Chief Justice should not be less than rupees 4,000 and that of a puisne judge rupees 3,500. A similar provision may be inserted if considered necessary. The minima may be raised. Article 222 provides for the transfer of High Court judges from one state to another. The consent of the judge is not necessary. According to the Memorandum of Procedure drawn up by the Home Ministry, consultation with the chief ministers concerned is necessary before any such transfer is made. The provision does not seem to have been used on any large scale. This provision seems to be derogatory to the dignity and prestige of the office of judge of a high court. The committee is strongly of the view that this article should be omitted. Articles 223, 224, and 224A may be considered together. They provide for the appointment of an acting Chief Justice, appointment of additional or acting judges of high courts, and appointment of retired judges at sittings of high courts. None of these three articles refers to consultation with the governor of the state concerned, as in the case of appointment of a permanent judge of a high court. The appointments dealt with by Article 223, 224, and 224A also should be made in consultation with the governor, who will act on the advice of his ministry. In fact, according to the memorandum of procedure drawn up by the Home Ministry, in cases falling under these three articles, the Chief Minister is always closely associated in making these appointments. This committee, while recommending that this informal procedure may continue, is of the opinion that the three articles should be amended to provide that the President should act only in consultation with the governor of the state concerned, and as in the case Article 217.1, the governor will be guided by ministerial advice. At present, whenever the constitutional validity of any particular provision of a state act is questioned, the High Court necessarily confines itself to that particular provision so challenged. The defect or lacuna, if any, that emerges as a result of the judgment is subsequently remedied. But sometimes later, another section or a particular provision of the same act is again challenged, and this process may be repeated any number of times in relation to particular provisions of the Act. The committee is of the opinion that there should be some machinery whereby the constitutional validity of an Act could be finally decided upon once any particular provision of the Act is questioned. The committee recommends that when any question regarding the constitutional validity or any particular provision of a state act is raised, the state government should be enabled to request the High Court to refer the question to a full bench of three or more judges, of whom one should be the Chief Justice. This bench should go into each and every provision of the Act concerned and give its decision on the entire Act. Once this decision is rendered, the constitutional validity of any of the provisions of the Act should be beyond challenge. The High Court does not possess powers similar to those conferred on the Supreme Court by Clause 1 of Article 143. It's the President who alone is empowered to obtain the opinion of the Supreme Court on any question of law or fact, if such question is of public importance. If the state government considers it desirable or expedient to obtain the opinion of the highest court in the state or any legal or constitutional issue, for example, any bill pending before the legislature or to be introduced in the legislature, there is no machinery to achieve the object. It's only after the bill becomes law that the matter can be agitated in a court, and that too at the instance of the individuals affected. This situation unnecessarily leads to litigation, and several legislative measures could be saved from being invalidated if only the state is empowered to obtain the opinion of the High Court well in advance of their enactment. We therefore recommend that a provision on the lines of Articles 143.1 may be made empowering the governor to refer questions of law or fact of public importance to the High Court for its opinion. In a number of states of the American Union, it's constitutionally provided that upon request by the executive or legislature, the judges of the highest court of the states shall give their opinion as to the constitutionality of proposed measures or actions submitted to them. In other states, it is provided that the judges themselves may suggest to the legislature measures for the improvement of law. A provision as suggested above will be most helpful and considerably reduce litigation.